All right, good morning to you all. You all will place your appearances on the record, please.
Good morning, Your Honor. My name is Jesse Dreiser. I represent Mario Fernandez.
Good morning, Your Honor. Patrick Bergen, Shanna.
All right, thank you. Good morning to you all. We are here, the state had filed a motion for clarification, and Mr. Mizrahi.
We did, Your Honor, occurred to the state, just kind of out of nowhere, that in an effort to save time, it may be appropriate to file this motion because ultimately prejudice has to be part of the equation in deciding how to rule on defendant's motions. And the court is not going to know what prejudice is. I don't see how the court could rule on the underlying motions. I understand why the court wanted a different court to review the alleged client privileged information. That makes sense. But then if the court is not going to know what that content is, puts the court at a disadvantage in determining what prejudice exists. And that's all about.
Okay, and then Mr. Dreiser, you filed a response. Mr. Curdy, you did not file the entire response.
We did not, but we opposed the safety motion.
All right, and so Mr. Dreiser, I enjoyed reading the whole last number almost. I thought we had an agreement, and I'm going to start just first with Fernandez, okay, which is my understanding was that the state of Florida, in the pleadings, Mr. Dreiser, I always thought it was one, but you're saying it's two, but I'm not sure what the second one is, but.
It's two. One was sort of the feature of what the state and I had talked about, but
It was called confidential communication, is my,
so
both of them.
both attachments are called confidential communication. What had happened was in discovery, we had learned the state had always acknowledged they were in receipt and had both of those and had looked at one, intended on using it, had looked at the other or had been made apprised of the other, did not intend on using it, but it was in their possession. We learned that in discovery, both of those attachments labeled confidential communication, one had a typo, it was confidential communication, just an extra O. And they were emailed directly from Lindsay Butler to Ms. Stifler, and there was text messages and communications about those documents. Those are part of all of the other emails that they just say they have not seen, but they uploaded to Next Point, and we learned that they had access to really the entire time. Even Ms. Butler had access to them.
Okay.
So those are the two that are the documents. And I'm not sure if this is what you want me to respond to, but I find this motion ironic that at the last hearing, I suggested to this court, you could do everything to avoid this issue if that's what the state wanted. I even waived any kind of recusal argument that you would see. What we are arguing is confidential communications, attorney-client privilege stuff. And the state didn't want to do it that way then. The court didn't want to do it that way, which I was fine with. I understand why the court did it the way you had done it. And I just want to say, you had told us back in December what your plan was, and you have never deviated from that in chambers. From the moment we filed our motion, you said, this is what I'm thinking I'm going to do. You've reiterated that at almost every pretrial. So for the state to come in today and say, just kind of out of nowhere, we thought of this, I don't find that to be a credible argument because they've had months to think about the procedure. And then at the last court date, you could not have been more crystal clear with us. You said, we have two documents. Do we have an agreement as to how we're going to proceed? I mean, you were baiting us to give you alternative suggestions or tell you that we aren't in agreement so we could iron it out. And it could not have been more clear as to what you wanted Judge Foster to do. And even, you may not know this, but when we got to the Judge Foster turnover, is really what I call it, wasn't really a hearing. Judge Foster we had prepared just the two documents. And we had done blackout copies and regular copies for the court. And the order, Judge Day's order was somewhat unclear as to whether the emails, I think it was the emails that referenced the documents But the state was like, you should read all the emails. So I ran back to my office. I blacked out all of the emails.
All what emails?
All 60 something emails, because I thought we had agreed on just the 2, but Judge Foster is now reviewing all of the confidential communications, all of the emails and the 2 documents, really, which wasn't, I didn't have any objection to that. That's what the state wanted. I figured, let's get it over with. Let's move this case forward. But even I thought at that hearing, we kind of got put on short notice as to what the state wanted. But either way, we complied. And then shortly after that, Mr. Mizrahi reached out and said, we want Judge Foster to review everything. And most importantly, and Mr. Crody and I both agree on, I don't think Judge Foster has jurisdiction to make a ruling in this case. He's not a circuit court. He was appointed as a special master to review documents, not to make decisions in the Fernandez-Gardner case. And I think that's...
Well, let me stop you there.
Yes,
So, from my understanding, I always thought, and I'm just sticking with Fernandez, Mr. Crody, just bear with me, okay?
Yes, Your Honor.
All right. Did the state believe that, I thought we were very narrow in what Judge Foster was actually going to review. And I thought the state was indicating through your last response, and the reason why I asked him to review just those things is that the state, there wouldn't be any need for Judge Foster to make any type of prejudice finding, or because the state was saying you did not have access. The state was agreeing that these 2 documents you have had access to, that your alternative view is that it is evidence, it is not attorney-client privilege. So.
Correct, but in analyzing both defendants' motions that we're trying to assist Mr. Fernandez, the allegations are not just about those 2 items that the state is, so.
Let's stick with Fernandez for now. I've got a different set of questions, because when I did the initial order, I didn't have Ms. Gardner's motion and what was going on, and I'm maybe.
But even, I'm sorry, even asking Mr. Fernandez, the allegations are the improper handling of alleged attorney-client privilege, even if unseen by the state of Florida, rises to a level that the court should remove the state of the attorney's office from the case. That's in Fernandez's motion. So the prejudice has to be part of that.
And I just...
Well, these documents, these 2 things labeled, I thought the state of Florida was saying this is evidence. So
That's true.
the case law is that there has to be, if the state inadvertently gets information that is in fact attorney-client privilege, there has to be some type of mitigating scenario by the state of Florida, and that would be essentially the line. That is, the state of Florida did try to mitigate anything. So you were saying it's evidence, it's not attorney-client privilege, and the case law seems to flow from that would be very decisive in what decision would be made. And I don't know why Judge Foster would need to make that. If you were saying you had access to full access, and you're saying it's evidence, Judge Foster says, let's say he rules hypothetically that it is attorney-client privilege, there isn't any need, because the state has already said, I've had it, it was evidence, and the case law is like, for example, I can't remember the name of the case, but it was like jail calls where the state had it, tried to use it as evidence, and they were saying it's attorney-client privilege, therefore this qualification should work,
Okay.
right?
No, I agree that although case law may indicate as to those jail calls, I believe in this particular case with this particular facts, prejudice has to be part of it. Because even if these are potentially attorney-client privilege, the contents of what was looked at are not communications between a lawyer and a client, like a jail call would be. So I don't think that just because Judge Foster rules it's attorney-client privilege in the case law applies. I disagree. Because the content matters. It matters as to the 2 documents we saw. The allegations that the defense has made goes beyond that. It doesn't just talk about the documents.
Why did you ask him to review the 16?
Because it's part of the defense motion. They have said that even though the state never saw these things, they should be dismissed from the case because they had access to it and put it on a cloud that other people had access to. That's what
But the
motion
state's
is.
defense always was that he never accessed.
Correct,
Right.
correct.
So
So
why is he reviewing it? If no one accessed it, then Mr. Dreiser is saying that he doesn't want anybody to review it, and that's what he made that very clear, like, and I wasn't under the impression that Judge Foster would be reviewing any of those things. I thought it was just gonna be the two.
the reason why first of all, he thought he was reviewing it. And he's asked the parties and the state said, yes, we agree you should be reviewing that. We don't know what's in it.
Okay,
But it could be, because based on their motion saying that we uploaded it to a cloud, the entirety of those conversations could be, hi, let's schedule a meeting.
okay,
And then the court can make two findings. One, that the state never had access to it, never saw it. And two, even if they improperly uploaded it to a cloud, it is de minimis and non-prejudicial. So you're able to make rulings on multiple avenues, not just one that we just didn't see it. Because the motion allegations go beyond the seeing of those items, they go to actually the mishandling of the items, even if you didn't see it.
what's your response to Mr. Dreiser's, that he doesn't have jurisdiction to rule on the disqualification motion?
Well, I agree, that's why I filed the motion. I think we need an order to give them that jurisdiction.
Okay.
Or, I mean, maybe I didn't realize this the first time. The state is fine with the court ruling on the ultimate motion, but you have to review everything. So, I mean, it doesn't matter to us what judge does it, but we think it should be the same judge.
This is very different than like a civil case, when a court would normally review attorney-client privilege and the problem is a civil court doesn't have any type of sentencing power. I potentially would have sentencing power in this case, and, you know, that's why.
Well, we understand why, you know, we obviously had no objection to that, and it makes perfect sense. The defense is willing to waive it, we have no problem.
All right.
The whole point of the state's motion is that it seems impossible for one court to rule on what the defense has filed without some knowledge, without full knowledge, like some full knowledge of what contents of the communication was for.
Mr. Dreiser, do you have anything else to add?
I would like to add that this is just yet another example of the state of Florida not following the procedures that are set forth either by agreement or court order in this case. This whole entire issue stems from an agreement that the state and I made at a pretrial hearing before my client was even arrested to make sure that our attorney-client privilege information would not be looked at. And then it got looked at. And access.
So I'm going to check this right now. I mean, this is not about the merits of the particular item. Okay. Not checking.
Well, I just, maybe I'm trying to get down to what will, I don't want to stay this case any longer than I have to. I want to get down to really the heart of what the dispute is so that we can move this case forward. And I tried very, very, very hard at the last hearing to narrow the issues for Judge Foster. When at the outset of this case, both sides were very clear there are terabytes and terabytes of information that are up in some cloud. And I did not want Judge Foster to look at terabytes and terabytes of information. I wanted him to look at the information that will help this court make a decision on the motions that were filed. So let me ask you this, Mr. Dreiser. What do you have to say? Like, I initially thought it was to Have you agreed to the 60 emails for Judge Foster to look at?
I was put in a scenario where it did appear he thought he was supposed to be looking at them. I think what he was supposed to be looking at is the attachments with the corresponding emails to those attachments. But I figured he was a special master, not making the ultimate ruling, not going to share these with anybody else. So my client authorized me to give all of the emails unredacted to Judge Foster's review. And remember, and I'll move on from my historical gripe with this case, but I will say many times up until now, they have suggested that the 67 emails that they've never seen, they're privileged. They're communications directly between me and my client and back and forth. And now, well, maybe they're not privileged. Maybe they're just scheduled. The state just keeps moving the goalposts, and they're saying, you need to review them to determine the weight of the prejudice. It's prejudice. They have my communications. Everyone had them. They were accessed, or they had access to them. That's not even in dispute. Ms. Butler had access to them. Everyone that was on Next Point had access to them. They were all on Next Point. And then it's just the two documents that they claim they have. I don't think once you review Judge Foster's order, which perhaps we should hold this ruling until I'm not exactly sure what it's going to look like. I assume it's going to be a privilege law. It's going to say this date, this time, this email, privileged. This date, this time, email, privileged, not privileged, whatever he finds. And then at that point, it may be very obvious to you whether you can or can't make the determinations in this ruling. I see no reason with that information alone that you would not be able to make a ruling.
What I was really looking for and I hopeful is that Judge Foster would review. He would determine if it's privileged, not privileged. Then I would be able to look at metadata. That is, whether the state of Florida accessed certain files, whether the state of Florida, anyone accessed those files. If the state of Florida didn't, prejudice to me doesn't really matter all that much, but you're saying it does.
Well, I agree, it doesn't matter as much. That's totally clear. If we didn't see it, obviously prejudice doesn't matter as much. But when you go to the defense motions, it does. Because they're alleging it doesn't matter if they saw it or not. Their motions say,
You're just saying this, that it got uploaded.
correct, because we uploaded it to the cloud. I think at that point, the nature of it, the court can make two rules. One, the state never saw it, therefore there's no prejudice. Two, even if they did see it and mishandle it and it was up in the cloud, that it is de minimis and non-prejudicial.
Okay.
And there are two elements, though, that the court is going to be faced with. There is case law that suggests what the standard is to dismiss just the ASA or ASA's handling the case. So the court saying, well, Ms. Stifler was in possession of this. Emails went to Ms. Stifler. I'm going to remove Ms. Stifler and anybody that she worked with or shared that information at the time, but I'm not going to remove the entire office. That's one finding the court's going to have to make. The second layer is whether we dismiss the entire Fourth Judicial Circuit and assign a new prosecutor, depending on how widespread that is. So I agree with the state that you have to know about access and what each person received, but it's a little bit more fine-tuned than that because there's kind of two entries for the case law.
Okay. Thank you. Let me talk to you, Mr. Curry. On the Gardner case, I had a different set of questions.
Yes.
When I reviewed and then amended the request for the special master to review, to me, your motion exposed more. The way I remember it is that there were devices. There was the Google Cloud, there's an iCloud, there were Google devices, their iPhones that were then search warrants were served on that, not given to the taint, team. And then there was an email from one of the officers to Ms. Stifler, I believe, asking whether this was like attorney-client privilege. Is that correct?
There were multiple communications with Ms. Stifler about whether or not things were attorney-client privilege.
And my understanding is that what was served on the search warrant was then uploaded to some cloud, okay? And then that information was divided out among law enforcement, not the team, not the tape agent, I should say. And they were going to go through it.
So,
Is that what?
so a little bit different. So you have next point over here, which was the first issue brought to the court's attention, where what I would call the unredacted or the information that had not gone through the taint team was uploaded and accessible. Separately, in February of 2023, after the agreement to use a taint team was agreed upon by all parties, the state went out and executed search warrants on Google and Apple for cloud data associated with the accounts that were linked to those devices. Those returns were then given to law enforcement, who began reviewing them without any involvement of the tape agent. And the one that, well, we know that they were both reviewed. The one that we find to be most egregious is they took her text messages, her iCloud text messages, so her iMessages that come in the form of an Excel spreadsheet, and the law enforcement team emailed them around, divided them up, and said, start reviewing.
How many emails is that?
How many text messages?
Yeah, text messages, or whatever this is.
Hundreds of thousands.
Okay. And you're claiming that would be attorney-client privilege, or some of them?
Some of them are, and we know that some attorney, at least messages between Ms. Gardner and her attorneys were reviewed by the law enforcement team.
There was also some kind of call between your client and Haycox, is that right?
Yeah, there was a recorded phone call.
Where did that come from?
So we found that on the data from my client's iCloud. And that was something that we found. And we do not have any information based on the depositions that was reviewed by a member of the law enforcement team. But I'll be honest with Your Honor, we are still finding more attorney-client communications up to this day. I mean, there's just, as we discussed, there are terabytes and terabytes. There are hundreds of thousands of messages. We've been sorting them. Not all of them can be clearly identified by phone numbers and things of that.
What did you give Judge Foster?
We gave Judge Foster that call, some text messages and some emails that we were identified between Ms. Gardner and her attorneys. I do want to tell the court that the access issue is only part of our motion. The gravamen of our motion is what we characterize in our motion as substantial misconduct, and that would be the actions by the prosecution team. And we believe that includes the state attorney's office, it includes the ATF, it includes the Jacksonville Beach Police Department, that there was this agreement, and then they all willfully and intentionally sort of disregard it and start going through materials that they knew were carbon copies of the phones that they were told they were not allowed to touch. And so that is the gravamen of our motion and why we're asking for dismissal, because we think that it's outrageous. We think that it was willful. We think that it was intentional. And we think that everyone knew what was going on and was okay with it. And that's not right. I mean, the attorney-client privilege is one of the most sacred privileges in the court, and you can't just do an end around of an agreement to remove attorney-client communications from data. And I do think, Your Honor, that the state's motion is premature because we don't know what Judge Foster is going to write. We don't know whether or not it's sufficient for the purposes of the motions.
My problem is I don't know. So are you telling me that you still haven't identified all of what you need Judge Foster to review? No,
Your Honor, because I accept the state attorney's position that they did not review any of the attorney-client communications that were uploaded to Next Point. At least the prosecutors, I accept their word to the court. Now, do I know what the Jacksonville Beach Police Department reviewed? No. I know what the ATF analyst reviewed because she told us. But I don't know what the other ATF agents reviewed or what the Jacksonville Beach Police Department reviewed as we sit here right now. But I also don't know that I've identified all of the attorney-client communications because there is so much data. And some of those communications cannot be sorted by emails or phone numbers. We are finding them as we go along, line by line, file by file.
Okay.
But I do agree with the court that, if the state did not access them, then, that's a different issue. That prejudice may not be important for that. Our motion, though, is primarily based on, at this time, the conduct by the state and its law enforcement team, which I believe the case law establishes they are all the state, especially when this was an active investigation involving the state attorney's office from day one. And so the state, what I believe in the prior hearings has tried to do is say, well, that's them. We're not responsible for what the police do. We're separate from them. And I don't think that's what the case law says. And actually, I think the facts of this case will show that they were actively involved in every step and aware that law enforcement was going out and getting the iCloud and going out and getting the Google return.
What's your position on Judge Foster making the ultimate decision?
Judge, since our motion primarily rests on the substantial misconduct, we believe that Your Honor is the appropriate person to make the ruling on the motion. We don't believe that Judge Foster, one, has the authority to do it, and then two, would be in the best position to do it.
Okay. Is there anything you want to add, Mr. Mizrahi?
I'm not going to respond to the entire argument today with regard to the ultimate decision in this case, which is what I mostly heard there, other than to say that's exactly why the court would be in an impossible position to rule. It's because of everything you just said. And so I thank him for supporting our argument, our position that the court has to have the knowledge of what the defense is claiming was misconduct before making a decision that the remedies that they've asked for. We have lots of responses to the arguments.
Judge, I don't think I said anything about necessarily the content of any of these communications being, at least at this time, being known to the court in order for the court to rule. We're focused more on the state's actions than the content of any specific communication. And I don't believe the case law supports that the court needs that information to find substantial misconduct.
Do you have an idea of what Judge Foster needs to review related to the Gardner case?
I believe it has help. According to the defense, we don't have the information.
Well, I mean, so the search warrants that were served on the Google, what's it called? Google.
They're served on Google Inc. for
Google Inc. and then the iCloud. Does Judge Foster have that from the state's perspective?
He has what the defense submitted to them as potential attorney-client privilege. That's what they represented to me.
I'm
saying we haven't submitted everything. Because we're still finding.
I'm saying there are still things that we were finding as of a week ago, but again, we've not gone back to Judge Foster and submitted them because they are not the center of our case. Just like Mr. Dreiser was talking about those 60-something emails, we don't know that those are necessary, as our position is simply that they went around the court ratified agreement to use a taint team and seized information and data that they knew had attorney-client privileged communications on it. And once they got it, they didn't give it to the taint agent. And there are issues with the taint team that I'm not going to get into. But they didn't give it to the taint agent, that they just started reviewing it because they felt they could. And that is wrong. It was in violation of the court-ordered agreement. The prosecutor's office knew that they were getting that data. And when they went to the second, again, I don't want to argue it, Your Honor. I think it's laid out in our motion, but we are focused more on the process that the state used and in their conduct than we are in any specific communication. And unlike Mr. Fernandez, the state has not told us that they have anything that they intend to use against Ms. Gardner that they should not have gotten their hands on. I think in Mr. Fernandez's case, I think the fact that they were going to use it as evidence is de facto prejudice because They've admitted that it's probative. They don't have anything in our case that they've said they've gotten their hands on with their hands. So we're in a little bit different posture.
Okay. All right, I'm gonna wrap this up and I'm gonna take it under advisement and issue an order, okay?
Mr. Honor.
Do you all have another date with Judge Foster?
It's all-
Yeah.
He was gonna let us know when he was ready.
I thought, reading tea leaves, it was an April 8th date, and I think he's probably using that as a wrong, from what I understand, he said.
I gave that just so that these cases don't fall off. I'll just keep it on the April 8th date and I'll issue an order on the state's, motion to clarify, okay?
Yes, Your
All
Honor.
right, thank you all
Thank you.
very much.